Welcome to the Urban Debate on Magicbricks Now, India's first property channel. I'm Faye D'Souza. Thank you so much for tuning in. The real estate regulator enters its final lap. The centre has now made public a second set of draft rules which are meant for the union territories. Remember, open for suggestion for the next 2 weeks. This fresh installment of rules for the regulator are also a sort of guideline for state governments when they form their own rules. Now, there are several very interesting points to note in these rules, first of which is no discrimination against buyers on any grounds at all. We assume this has to do with gender, caste, religion, or sexual orientation. Home buyers have the rights to choose where they wish to buy a home and where they wish to live. The other important highlight, of course, the new rules is a new registration fee. There's a difference in the registration fee between residential and commercial projects. The centre has opened up a list of draft rules for public suggestion for 2 weeks. The very, very interesting piece of information that's come in from these rules is something called a compounding fee. Now, remember, the initial bill had mentioned that a developer may be jailed for up to 3 years for not following the instructions of the appellate tribunal, which is a court. These rules actually state that if a developer pays a fee of 10 times the project cost, he may, of course, avoid jail altogether. So there is a fee that can be paid to avoid jail. These are the big points that we're looking at and that we're debating this evening. Joining me on the show, Navin Raheja of Raheja Developers in Delhi, Rohit Gera, Managing Director at Gera Developments in Pune, Uday Wavikar, Vice President of the Consumer Court Bar Association, Maharashtra and Goa, who spent a fair amount of time examining the bill with us. Gentlemen, thank you so much for joining me on the show. Uday Wavikar, the thing that caught my eye, first of all, is this whole point of no discrimination. Now, it does not specify what we mean by no discrimination. It just says on no grounds whatsoever. Personally, I think it would be a massive move if people of all communities and all religions were allowed to buy homes wherever they could legally and lawfully do so. But do you think that it's going to open up a can of worms?
Yes, definitely, because it is a welcome move, Faye, because I have fought against the societies. We said bachelors, spinsters and foreigners would not be allowed their places in the society for owning a flat. But here, apart from economic class and gender, there's no color, caste and creed. Now, this is going to open. Now, for example, if there are Parsi colonies all over India, these are specifically under the trust for Parsi communities only. The land is bought with an object that houses will be given only to Parsi community. Now what happens is, if there is a redevelopment and there is a sale portion, if RERA applies to it, then anybody can buy. People may fix prices for other community higher, but that discrimination, it will be a discrimination whether that will be allowed. Why Parsis? It will be same thing for Jain community, it will be same thing for so many communities. There are different lands and different projects.
Is it fair to, and I'm going to read this out to our viewers so they can understand it. It says basically a declaration will have to be submitted by the promoters of all development companies that says a declaration stating that the promoter shall not discriminate against any allottee at the time of allotment of any apartment, plot or building as the case may be. So, like Uday Wavikar was pointing out, there isn't any specification here on what sort of discrimination we're talking about or whom we're talking about discriminating against, but it is a massive move for those people who are not allowed to buy or to live in certain specific buildings. Rohit Gera, as the promoter of a company who's going to have to make such a declaration, what's your response to this?
Faye, I think I have one fundamental question, and that is, under which clause of the Act is this actually permitted? Look, eventually the rules have to be framed under the framework of what the Act says. You can't just go beyond the Act. Today, apart from and look, I understand and I appreciate that this is a noble idea and it's necessary across the country, but I don't think this is the way to bring it in. First, I think apart from religion and so on, there are also issues to do with developers are doing senior citizen housing today. How about that? Why was it not possible to just state under these categories you can't discriminate? So at least you have the freedom and flexibility. If you're doing a redevelopment like was stated earlier, if you're doing it for a certain, you take army personnel for example, they want to do a housing society for defense personnel. According to this, you can't do that. So I think it's a well-intentioned idea. It's in the wrong place at the wrong time.
Well, Rohit, I'd like to rebut that. I mean, any sort of redevelopment, like Uday Wavikar mentioned, has a saleable portion. There is a portion of it, especially if we're talking about, urban areas, there is a portion of it that's up for sale. There's no reason why anybody from any community shouldn't be allowed to buy legally, lawfully from that saleable portion. Agreed, if you've sent it in for redevelopment, then the people, the community who own the land and who own the old buildings should be given first priority. But there's no reason why people from other communities shouldn't be allowed to buy if they can afford to do so.
I completely agree. I completely agree on that. But all I'm saying is, why? Firstly, my first question is this really permitted as far as the law is concerned? Secondly, even if it is, why not be crystal clear?
As far as the law is concerned, Rohit, I'll remind you, when the law was debated in Parliament, the last debate that took place in Rajya Sabha, this was one of the suggestions that was made to the minister by the opposition. The minister took in the suggestion, said that's a great suggestion, we will include it. It's not part of the bill that's being tabled right now, but we will work it in. Now, let's accept
you can't work it in through a back door. I'm sorry, you can't work it in through a back door.
It should have been part of the act. I don't see anything wrong with it. I personally don't see anything wrong with it. And let's take this one step further. Rohit Gera, you are part of CREDAI. CREDAI that's been making a demand, asking for local level permissions to be brought under the purview of the regulator, which is not part of the existing bill. Now, if you want things to be changed on the state level, you want representation to be taken into consideration at the state level, it should be allowed on both sides. Why should we only then have to follow the bill as it was passed in Parliament?
So all I'm saying is, look, the points that you raised about religion, race, gender bias, I completely agree. Right?
Okay.
Why couldn't they just write that? What about a developer who wants to do senior citizen housing? What about a society which comes up which says we are a society of defense personnel, we want to do a development, they're actually covered as promoter, we want to do a society for retired defense personnel. Where is the need to keep it so ambiguous?
Your problem is just the clarity then? Or the lack of
absolutely. Absolutely.
Uday Wavikar, clarity can be worked into. These are just guidelines.
I believe what he says is correct. We really need clarity because certain plot of lands, take collector's land, MADA, SRA, they are with a particular purpose and they are with a particular project. Now there also there are reservations. Apart from the reservation, the constitution allows the object clause. Like he was saying, originally the societies were of the common culture, common religion, common class, and they were successful. Now if you form a society, as he rightly says, for the defense personnel, or if you form a society for, let's say, artists, cine artists, or you form it for television artists, for the welfare of them, and then you are saying that anybody can claim and buy that land, or which is allotted by 10%.
Uday Wavikar,
what really requires is
we need to focus on the fact that living in the city of Mumbai, you and I both know that there are buildings that refuse sale and refuse residence to people of certain communities, whether that's because of gender bias or sexual orientation or religious, or whether or not they're vegetarians or non-vegetarians. Now, this is a clause that effectively stops that. Agreed, it needs to be clearer, but it effectively stops that. And I personally believe this was much overdue.
I agree with you, Faye, but then it has to be clarified and properly put it. Otherwise, people will try to take some bypass by saying that the constitutional rights are not allowed, object clause is not allowed. If you look at the promoter definition under RERA, it is so clear that everybody and anybody can come in. The person who wants to construct a house, person to whom contract of construction is given, and person who sells it, if they are not the same person, are the promoter developers, which means everybody under the sun comes under the promoter developer definition. And this will be interesting to watch how people will take a bypass from this. But
this is another thing, Uday Wavikar, I want to ask you about this.
One more question in cities. Issue, that is a burning issue. Today the bachelors are not given places, sprinters are not given, foreigners are not given.
People from the media are not given places to
and lawyers are also
Just 1 second, I'm sorry. Can I just button on this?
Okay, go ahead.
As far as these issues are concerned, this is all discrimination taking place, which shouldn't happen. But it's happening where projects are completed. There's no involvement of a developer. There's no developer who says, if you're a bachelor, don't buy from us. I mean, come on. This has got nothing to do with the RERA.
No, but okay. But let me back this up a little bit. Now, if we leave the bachelor portion of it out, the fact that most, and I'm not pointing at developers here, at least in the city of Mumbai, several buildings wind up dominated by certain communities. Whether or not it says so in their, in the clauses of their community guidelines, it winds up they're being dominated by a certain community because those are the people the developer sold to begin with. And those are the people who then form the society, who then write rules saying we will not allow anybody else in because we're largely a vegetarian community. So Rohit Gera, let's not pretend that it has absolutely nothing to do with where the problem starts with. I'm not saying all developers do it, but that's where it starts from.
I don't disagree with that. There is certainly some element of discrimination that's taking place across this country, and I think we need to get rid of it. I completely agree with that. I'm just saying be clear.
All right, so clarity on that particular point, but it's an excellent one. I personally welcome it. Anybody who feels otherwise, I'll put my Twitter handle up on your screen. Feel free to get in touch and we'll have a healthy debate about it. But I think this is something that was much overdue in India as a country. Navin Raheja, very, very interesting declaration that also needs to be made by all promoters. Audited balance sheets of promoters of the preceding financial year, income tax returns of the promoter of the 3 preceding financial years have to be declared, and the registered entity annual returns for the last 3 financial years of the parent entity have to be declared. Now, most developers are not listed entities. They don't declare their results every quarter. This will change everything for an industry that has been, in all fairness, a little cagey about its finances.
Very, very good move. I would say that this will actually wipe out the unscrupulous, non-serious, opportunist players coming into the field without any experience, without any money, and just becoming mafias to collect money from the gullible public. So this particular single move by the government to make it a mandatory declaration will actually separate the right kind of developers and the non-serious and non-performing developers, or which are not even the developers, So this one thing is actually going to make a lot of change. People will be able to see whether the developer has a financial capability, whether there is money, whether there is a track record, whether it is a genuine company. So these all things, I think, now will become available online, and I think there can't be a better thing. I will say this is the best declaration which is asked for. Along, I think there are many other points also, track record of developer. So overall compliance reports, even court cases, everything, in 60 points total. These declarations are actually going to make a lot of difference.
In fact, yes, 60 points altogether. It has details that are requested on the developer himself, the enterprise, the name, the parent entity, ongoing litigations, past litigation, track record of the promoter, number of completed projects, details of ongoing projects, years of experience of the promoter in particular. It goes on to say compliance, registration, sanction plan, registrations from authority, details of the apartments that are being sold, consultants that are hired, registered agents, location, development plan, amenities, all of those things will be declared. PAN card of the promoter, balance sheets, financial details. The promoter has to upload also, this is the interesting part for buyers who've had trouble with this, status of the project of every building with photographs of each floor of the internal infrastructure, common areas of those photographs will have to be uploaded and updated once a quarter. Status of approvals received, approvals applied for, date planned of application, modification, amendments, revisions, all of which will have to be declared and uploaded and updated once a quarter. Rohit Gera, 60 different points of details that will need to be uploaded on every project and updated once a quarter. How does that make you feel?
It's interesting. You read out all the things you forgot to mention in that date of approval applied for and date expected. That's also something that I'm supposed to provide.
That. Approvals applied for and expected date of receipt.
And expected.
Yes.
How is that in our control? It's ridiculous.
No, but I think, if we look at it this way, Rohit, if you actually have to say, okay, this is when I applied, and it's something that you haven't got for 6 months, then your customer knows and the regulator knows that it's not your fault.
And that's all right, but then you're asking us to point out when it's expected. So that's just a small minor point. Look, my other concern is the quantum of information. How many customers? Mr. Raheja said that it will bring about a lot of transparency and so on and so forth. Some amount of it, I agree. You conduct a personal finance show. How many of your viewers can actually read a developer's balance sheet, see the P&L statement to come to a conclusion whether they have actual financial capability, stability and so on? It's impossible. It's totally...
Well, Rohit, I'll tell you what, that's what I'm here for. I will read the balance sheets. I'll tell the viewers whether or not it makes sense, whether or not they're financially sound and if they have the ability to execute the project. That's what we're here for. The idea, I think, that we're looking at is the fact that this information will actually be in the public domain, accessible to all of us. Uday Wavikar, I welcome 60 different points of information on every project.
Faye, I agree, and I do not agree with Mr. Gera for two reasons. One is, don't underestimate people, because people can have the advantage of consultants and get it analyzed, and they are available today. Second thing is that he was telling that how I can tell about the approvals. I am not a fortune teller when an approval will come. But the point is, you are expected to be a professional. You have done several projects. By and large, you know how much time for a particular project it took of yours and what are the conditions. Because if you look at the cases that we deal in consumer court at the National Commission, Supreme Court or otherwise in city civil court, where municipality comes with non-compliance of the municipal corporations or various such corporations come with a non-compliance of developers, that goes to a tremendous list than what is promised and what is performed. So I think as a professional, you are expected to know estimated time, and it's good to have such a transparency. People will at least understand the level of projects that you have done, because ultimately the part of your compliances is also your job.
So look, make no mistake, from a developer bringing out past projects, track record is great. For people like us who've been in the industry for decades now, it's wonderful. Fundamentally, that, there's nothing wrong with that.
No, you have excellent license also.
Well, we've still been stuck waiting for occupancy certificates in different states. We've had to take the corporations to court.
Mr. Gera, the problem is, I'm sorry to cut you, but
the reality.
I'm sorry to cut you, but the problem is, builders do not go to High Court with a writ petition against corporations. If they delay, there are various other reasons we know.
I beg to disagree. We've done it.
You have done it, but how many of them do it?
Okay, all right. I want to bring in Navin Raheja into this conversation. Navin Raheja, approvals received, approvals applied with an expected date of receipt. In an ideal world, we'd also need the local level municipality to upload how many approvals have been given and which have been rejected and stalled and why. But we don't live in an ideal world. In the meantime, just the fact that you can declare when your approval application went in and how long you've been waiting to the regulator and to your customer, I think that alone is a step in the right direction.
Absolutely right. Actually, we have been demanding all through that please bring in the approving and local authorities also under this bill and make them accountable, because developer can only perform his part. The project delay or any problem coming is largely due to multiplicity of approvals. There are more than 50 different areas where we have to move in applications and keep on following them. And at times, in one department, you have to move on for years together to get just one small stereotype of letter. So these departments, unless they are also made accountable, we applied, yes, I can apply. I have complied with all the requirement and made application, I can put it, yes. But getting it is very difficult. I don't think it is so easy for, and the things are so straight in India that whatever you well-intended work you do, whether it comes back, so that is not in your hands. So approval applied and approval received or approval rejected, reasons given and reapplication done with improving the reasons. That part can, I think there's no harm in sharing transparency with all the customers, because that will keep the things straight always.
Uday Wavikar, could this possibly be government accountability through the back door?
In fact, I agree with Navin Raheja's suggestion or Mr. Gera's suggestion that somewhere you have to have one window clearance. You know, there are so many
I
windows.
agree. It does make sense to have a single window clearance, but again, that's not something that's going to happen right away. We've been asking for it for a very long time. We've also been asking for approvals to be brought under the purview of the regulator. That hasn't happened either.
I appreciate one thing this clause has really bought in is that at least the consumers know that whether you have applied or not. 99% of the cases the builder doesn't even apply for an occupation certificate. And then when we go to the courts, he says, the promoter developer says, and I can name reputed promoter developers here.
Please feel free
if you
to
ask, the point is they tell straight away that we have not even applied. And when Justice D.K. Jain asks a developer, have you at least applied?
Uday Wavikar, I know Rohit Gera is going to turn around and say, don't paint the entire industry with one brush, don't generalize. So give us the names of these reputed developers that you're talking about on this one particular case.
See, I mean, I can list to you the developers.
Right.
The cases are sub judice. On the judgment, I will give you. But the point is, the question is that such developers who are not applying also, they will have to now apply and give a date. That itself is a great point, and I agree with Navin Raheja that this transparency has to come in, that the efforts on the developer side, promoter side are honestly done. They have applied for occupation certificate or building completion certificate. 40 to 60% cases in Mumbai city, they do not have even building completion certificates. So therefore, all this will come out, and I think this is a welcome
the interesting thing also to note is the fact that right on top, on page 4 of this massive document that was released that we've been reading through, it says, of course, that any ongoing project without a completion certificate comes under the purview of the regulator, which means that the promoter shall disclose the size of the apartment based on carpet area when he registers it with the regulator. But if there has been a sale before the regulator that was made on either super area, built up area, saleable area, that sale is not affected. The validity of that agreement continues between the promoter and the allottee to that extent. Navin Raheja, the grey area of whether or not ongoing projects get brought under the purview of the regulator, that's obviously very clear. Anything that doesn't have a completion certificate will be brought under the purview of the regulator.
Let me tell one more thing. There are several of our projects also where we receive a completion certificate. First we receive license, we make payment of external development charges, infrastructure development charges, all sorts of demands, whatever they come. Electricity augmentation charges, we make every payment. After that also, after getting occupancy certificate as well, the authorities are not able to give you water connection, or they are not able to give you electricity connection, because they say we don't have that kind of infrastructure in our substation to give you electricity. Now, who is accountable at that stage? And regulator does not cover that part. That part needs to be covered to make these. They are also taking money in advance. Government agencies, whether they are electricity department, whether it is a municipal corporation, whether it is a water supply department, all these agencies, they do receive money, and they take money and keep the money for many years without delivering, and ultimately customers suffer. They should be brought, whether government departments or whether private developer, we all are part in India, we are all Indians. We have to perform, we have to deliver to our citizens. It does not, there should be no discrimination because those people are in government and they are under government service. They are not accountable to provide any these facilities, and they are not accountable, they cannot be covered by regulator. Why they cannot be covered by regulator? They should also be covered by regulator. So these things, single window clearance, we have been demanding for many years now. I can, we are also human beings. We can.
But Mr. Raheja, I have a question for you about a single window clearance. Mr. Raheja, I have a question for you about a single window clearance. Let's assume tomorrow you are given a single window clearance, where your entire file that includes, fire and environment and any other type of permission that you need goes into one window. Once it goes into that window, it has to then pass from department to department. Every department has to give it one approval. You will still have to liaison with that government to make sure that happens. Unless, of course, we change the way these permissions are being approached, how will a single window clearance work? I think the push here should be more on accountability from each department than just for one window where you submit your entire docket.
As president of NAREDCO for 2 years and as chairman of NAREDCO for next 2 years, we made the entire system sitting with government and told even that. We have even requested that we can finance and fund a software also. And in that you have to we have to have 3 panel of consultants like banks, In banks there are consultants who do title verification, financial due diligence. In this case, the third is the panel of well-trained architects on all the building codes related to construction, structural safety, fire, environment compliance. These all consultant panels, government approved, are there already in every state. So they can be well trained by the government, and they can, under that, they can, for a particular project, a developer can approach them, get their consolidated plan worked out, upload it on website along with the requisite fees to the licensing authority. They can, on a click of a button, it will go to
in an
every
ideal world, Uday
department.
Wavikar?
They can check
this is a good
and
plan, but it does not happen, and it is not on one-sided.
It takes just 30 days.
Mr. Raheja is saying, and I really appreciate.
It just takes 30 days. We demonstrated it takes 30 days only to get
So
all the
I don't think it's
it's
the
Mr.
plan that we are
concern.
questioning, Mr. Raheja. We are questioning the intent of bringing that plan in.
Faye, what happens is even builders and developers change their plans. There is a building where the IOD is for 12 floors. Suddenly you get more FSI and TDR, or you put the TDR, make it 16 floors, and then go for
I'll argue with that, Uday Wavikar. That should be allowed. That should be allowed. If there's more FSI available as a developer, I should be allowed to exercise that.
Saying once you propose a plan, you declare to the various buyers and give them that there will not be any building in front of them, and suddenly you bring one another building in front of them and you change the plans without approvals of municipal authorities well in advance. Then what happens is there you get caught up with the occupation certificates and completion certificates, which is not fair. Apart from this, what I would really feel is what Mr. Raheja is saying and even Gera is saying is correct. These authorities are also delaying the approvals for a long period. In turn, the consumers are also suffering and the developers are also suffering. But where the plans are straight, non-compliance of the developers also are many. They have to be reconciled, and I think CREDAI can come very heavily here.
All right, Rohit, do you want to respond to that?
Faye, actually, I think I want to respond to the other point that you started, the path that you started going down. That is to do with the bringing in the current projects under RERA. That was very clear even from the Act. The question that we have, which has not been cleared, is the moment you register, you're automatically covered under the 70% designated account rule. Now, the practice thus far has been that people have by and large paid about 70 to 75%, maybe 80% of the flat purchase value by the time you complete the RCC. Today, if that's going to be drawn out in percentage of the progress done based on the work done, this is only going to be about 30%. So where projects are currently underway and these funds have actually been taken by the developer, we need to address what happens in those situations. How much time does the developer have to top up that account? Because if you don't have complete clarity on this, all projects will come to a standstill, virtually.
But Rohit, okay, here's my argument, right? Here's my argument. If the developer can withdraw the amount based on completion of the project, and if you're talking about an ongoing project, then that project will have reached a certain level of completion towards which the developer can withdraw that amount. So let's square off that amount then. Yes.
Let me explain. So for example, if I've completed the RCC work of the project, that means I've constructed about 30% or 35% of the project. Okay?
Okay.
The practice thus far has been that by that stage, developers would take between 70 and 80% of the total amount that was due.
Okay.
Right? So let's suppose I've reached the stage of I'm on the last slab of my building and I've collected 75%. but I've actually spent on a construction cost, I've spent 35%.
Okay.
Okay, which means I've actually collected more in terms of the progress that's been done than what I could draw under the current RERA rules.
Okay.
Where does the funding for that remaining gap come from? If I've already overdrawn, because that's just been, the norms are changing midway for ongoing projects. New projects is crystal clear, there's no problem, we'll follow that. Unless and until there is clarity on ongoing projects, and if you say you can't draw any more money because you got to top up that account,
Right.
where are developers going to get those funds from? And I'm concerned that those projects will come to a standstill for want of money.
Uday Wavikar, I think we'll see some amount of distress and M&A happen in the industry, obviously, when the regulator comes in. But that's something we're all expecting.
I agree entirely with Gera on this point, because there has to be a clarity for those ongoing projects which are not completed. He is rightly said new projects, okay, there is a follow. But ongoing projects have already invested lot on the project. And thereafter, if you ask them to cop up 70%, that is going to be a real stress. Maybe Maharashtra is thinking, but...
Uday Wavikar, that's my point. They're not going to have to cough up 70% because the project would have reached a certain level of completion, which means that they are allowed to withdraw that to the extent of that completion. So it's not the entire 70%. If you've completed 35, you can withdraw up to 35. There will be a calculation.
Yes, but Faye, what happens if you've withdrawn 70, which was the norm till last week? What happens to the remaining gap of 35 which has been withdrawn already?
The developer is just going to have to top that up, Rohit, to just make sure that he has the financial ability to finish the project. I think that's the whole idea behind this rule.
No, but there is one point.
It's very easy to sit in the studio and say developer has to top it up. Do you know how many hundreds of thousands of crores are going to be needed across the country to top that up?
You know, I'll tell you what I do know. I know how many hundreds of thousands of buyers have been waiting for homes for 5, 6, sometimes 8 years because developers don't have the finances to finishes those projects.
I don't disagree with you.
Just to guard from that
situation,
if this is what we have to come to, I don't see a problem with that.
No, Faye, I think you're missing the point completely. All I'm saying is we need to have a proper transition plan to go from current to future state. You can't say future state is brought into an entire industry overnight and you're going to have developers stuck for money. Ultimately, if that does happen, this whole M&A talk is meaningless if a person does not get his home on time as being envisaged. If anything, this will further cause delays as far as home buyers are concerned. That's my concern.
But Mr. Gera, our concern is that those 70% withdrawals you are saying, what is the proof that you have not used for other projects?
No, let us suppose
because that accountability has to be there.
The process of the past. I'm not disagreeing with you.
Most of the developers collect on one project, use on other project, and therefore projects get delayed.
But that is exactly why the new law has been brought into force.
Then let us implement.
So I'm not in disagreement with you.
Let us bring back that money that you spend on the other projects.
Well, okay, let me point this out. Rohit Gera, there are several developers in the market right now who already have a certain level of financial prudence and hygiene when they come to managing finances on their projects. They don't divert money from one project to another. They maintain separate accounts for each project. This will actually set those developers aside from the ones who've been diverting money. It's a move that I welcome. We'll be able to tell the good ones from the bad ones. We'll be able to tell the ones who can actually turn around and survive the regulator are the ones who are following the rules to begin with, who had a certain level of hygiene in their systems to begin with. The customers will now be able to tell the difference. Would you argue with that?
So can I just ask you one question? What percentage of developers do you think this is?
I'm sure it's a very small percentage.
One half, which means 99% of all projects would willy-nilly come to a standstill because of this.
I disagree, Rohit. You know, the 1.5% that you're talking about are large developers who are building a large amount
We're in that category. We're in that category. So in that sense, it's great. But I'm talking about it from an industry perspective for hundreds and thousands of home buyers. All I'm saying is, why could they not come up with a simple thing? For example, you can still withdraw and you've got a 12-month window within which to catch up and have that amount in escrow.
There's a 3-month window, I think, that's available right now. Navin Raheja has not commented at all. Navin Raheja, do you believe that the escrow account is unfair on ongoing projects?
See, for ongoing projects, I think it will take time it cannot be done the way it is being told to, that within 3 months you will regularize everything. It's not possible. Project budgets at times, they don't work the way you envisage them to work. So there should be, I think, for ongoing projects.
Raheja, if we know that this is happening, we are holding the rules in our hands right now. The regulator is not coming for the next year. Don't we already have time between now and say the end of the year when the regulator does come? Isn't that enough time? Plus 3 months.
Yeah.
So we're talking about 9 months.
I think it is the right time for developers to
start cleaning up their bank accounts.
It is. Yes, it is best for developers to finish the project.
Uday Wavikar, do you think states will
if you finish the project before the regulator comes?
Mr. Raheja and Mr. Gera, there's a class question coming from FAE that Maharashtra state will dilute this. I believe there are proposals and there are a lot of grapevine saying that this might come to the 70% of the construction cost, which I feel is most unfair for consumers.
If it does become 70%,
you are selling cost 70%. Where is the construction cost?
Actually,
how can you go beyond the act?
Construction cost now.
I will answer that to Mr. Gera.
There are talking about the balanced construction estimation.
Mr. Gera has got a very pertinent question, but these states are giving authorities to modify this within the ambit of the act. But the now question is, he is right. But then if this authority is given,
to be fair, Uday Wavikar, it said to a maximum of 70%.
Yes.
Of the project cost.
Yes.
No, it doesn't say maximum.
Right, hang on, let me read out the bill.
It says 1 minute. We'll say it says the selling cost.
Okay, let me read out the bill to you as it says. It says 70% of the amounts realized from the real estate project from time to time shall be deposited in a separate account and maintained in a scheduled bank to cover the cost of construction and the cost of land, and shall be used for only that purpose.
That's right. It's crystal clear. 70% of all amounts received have to be put into a designated account to be used for land and construction. There's no scope for diluting this.
We're talking about the new set of rules that were released by the central government on RERA. These were released for the union territories, but they're sort of broad suggestions to the states as well, as each state works out its rules. With me on the show, Uday Wavikar, Rohit Gera, Navin Raheja, and joining me also is Ramesh Prabhu, Chairman of the Maharashtra Societies Welfare Association. Ramesh, thank you for joining us. Yeah. A very interesting point that we must talk about. And I'm going to call it money instead of jail, because when the bill brought out, and this is to point out, what Rohit said in the beginning about going outside of the bill. When the bill was brought out initially and tabled in Parliament, one of the things that was most debated was a clause that said that if a developer violates a rule from the appellate tribunal, he could face 3 years, a maximum of 3 years in jail. Now, these rules actually state that there's something called a compounding of offence fee of 10% of the estimated cost, which means that if a developer has been taken into custody and he pays a fine of 10% of the estimated cost of the project, he will be set free, and no proceedings shall be instituted or continued against such a person in any court. Ramesh Prabhu, do you see this as a complete dilution of the clause that was passed initially?
In fact, the law, when it was originally enacted, it was saying that there will be prosecution. But later on, it got diluted as when it was debated, and ultimately it said that the penalties can be levied, and penalties was up to 10%, and that means a discretion was there to the tribunal or to the appellate authority to decide about the penalty that is to be levied. But now in the rules, which is made very clear that 10% of the estimated cost of the project. So therefore, I think they cannot escape. And therefore, there may not be prosecution. If they don't pay, that means there is a violation of the law.
No, see, okay, so I want to tell you this. I remember the Urban Development Ministry came out and very clearly said to us that, listen, we're bringing in this clause about a prison term as a deterrent, because we want more developers to follow the rules. Now, if you now at this point release a note that says for 10% of a certain amount of money, you can avoid prison completely, then what sort of a deterrent are we talking about, Uday Wavikar? This is completely watering down that rule.
Completely watering down. If you look at the Maharashtra Flat Ownership Act, there is 3 years imprisonment and there were criminal proceedings on. criminal proceedings were taking time. So on the MOFA, consumer courts are sending builders to the jail. I am not saying all, but those are totally defaulters after collecting 100% amount, not delivering the flat, has gone to the jail. Just last week, one developer went to the jail. Recently by Maharashtra State Commission.
Okay.
But now what has happened here is, this is completely watering down by paying penalty. If a builder, it is like regularizing an unauthorized building.
Let's be fair about the fact that 10% of the estimated cost of a real estate
of the
is a lot of
estimated
money.
cost of the project.
It's a lot of money.
Look at,
it is a lot of money.
It is a lot of money.
Cost of project.
No, but the deterrent of the jail cannot be substituted by, in fact, this will give, because the project costs, today the project costs are increasing, market prices are going up, and when the market price go, last 30 years, 300% the flat prices have increased.
See, if you don't pay the penalty, that means there is going to be prosecution, he will be put behind the bar. Further appeal cannot be taken up unless until the penalty amount is deposited with the
Mr. Prabhu, you cannot.
Okay. One second, let me bring the developers in
you
here.
can't get away with murder, say that I'll pay the penalty.
All right, Rohit Gera, respond to that. The penalty that now comes in instead of a prison term, is it still a deterrent for developers?
Look, I think it is certainly a deterrent. There's no question about it. The quantums are very large. I understand that the sentiment today is so anti-developers that there is a cry to kind of, hang them, jail them, all of that. I understand where that is coming from, and in most cases for good reason. You've taken 100% of the money, you don't deliver, people are paying rent, EMIs, in horrible situations. I think it's deplorable. But I think on an overall basis, please appreciate 10% of project cost is a huge amount. Okay, and yet I'm not one to say that it should be completely as an option. I think if it could be something where you say, okay, that we have an option of either paying the fine and let a judge decide if it is a serial defaulter, if they've done things which are just gross violations, intentional violations. I think certainly in those kind of situations, please jail the developer, right? But where it is a lapse of some of some issue, certain things like that which were inadvertent and so on, and you can have a situation where there is a lapse and you are guilty, pay a hefty fine and move on, because eventually from the consumer's point of view, you want the developer to be there to complete the project, not to be rotting in jail. You don't get your home if the developer is sitting in jail.
Well, to be fair, there is also a fourth point on this that says that once the promoter, as the case may be, will comply, will pay the fine and get out of jail, he has 30 days to comply with the regulatory authority or the appellate tribunal. I'm assuming if it's a repeated offence, then that option will no longer be made available to him. Navin Raheja, how are you reading this, this particular clause?
Just tell me, what is more important? Is it more important to deliver the project to the customer? Or is it more important to fulfill the egos of some people that, okay, the guy has been sent to jail, but who is the sufferer? The person, the customer is going to be the sufferer in that case. Ultimately, the project is to be delivered by the same very person. So, a 10% penalty
but
in a project
Mr.
also
Raheja,
runs
I'll tell you this, almost all buyers we have spoken to, all buyers we have spoken to, their fundamental interest is in just receiving their homes. Nobody wants to send anybody else into jail, especially since it involves such a long drawn out legal process that most average customers are not even interested in doing. They just want their homes. It's only when you push them to that final edge of their sanity where they say, if there's no other option, I'll at least like to see this particular developer pay for cheating me.
Yeah, absolutely.
I agree with that.
And that should happen.
I understand that, but at the end of the day, you are aggrieved, you have suffered, but you have to see the larger interest is that maybe we should always look at how to give a solution for success, and the success is that he gets his delivery.
Okay, fair enough. Navin Raheja, I
think just one second.
I just want to point out. I just want to point out before we move on. Rohit, just give me a second. That the bill allows customers to get together and appoint another developer to finish the project if they feel that the developer who actually started the project is unable to do so, whether or not he's rotting in jail. So I think that that would be covered. The fact that we don't want to punish our developer at all, because how else will we get our homes? I don't think that that's a point that should worry customers anymore. Rohit Gera, go ahead.
This will.
I think it's easy. You just have a three-strike rule, for example. A developer may be allowed once or twice to use this clause. Use the clause once or twice. Beyond that, sorry, the jail term applies. If you're a habitual offender, right? If it's happened by mistake, it's all right. We let you pay a huge hefty fine, move on, but that's it. The next time you can't.
The other thing to consider, Uday Wavikar, and I know this is something that's really bothering you, that at the end of the day, after the appellate tribunal, you have to apply to High Court. And if there's a stay in High Court, we could go on for years before we see anybody go to jail.
Faye, I am really upset on this particular provision, because this is like watering down everything that Parliament had said. Parliament very clearly stated that we do not want builders' cases to go to city civil court. We want them to only go before RERA authority and consumer court. Having said that done, suddenly they are coming out that first of all you go to an local court, that is at the district level with an adjudicating officer who will a district judge, then go down to an capital city like Mumbai or other cities or Nagpur, where there will be another RERA authorities which will have the High Court judge, and then appellate authority to that will be High Court. Now the question is, from one city civil court you are going to ocean of city civil court, where there are a lot of cases already pending, and with the technicalities and with the cost, if the cases are admitted and stayed in High Court, it will take number of years for consumers to get the justice. Instead of that, 1 minute, let us have the example of consumer courts. You have an independent central act where you move fast to National Commission and National Commission to Supreme Court.
Right.
Therefore, the cases are not delayed, and alternate remedy is only National Commission.
Ramesh Prabhu?
If you start burdening High Courts with this, what is going to happen is justice is going to be delayed and everything can be washed away, because every time you can't expect High Courts. And what are the costs involved for consumers?
See, there is a special remedy which has been given, that is a regulatory authority, then appellate tribunal, and then of course as a writ petition under Article 226, 227, one can always go.
No writ, it is the appellate court is an High Court court. Writ is a different thing, Mr. Prabhu.
Yeah, agreed. So therefore the appellate provision has been given to the High Court.
Appellate court.
Because ultimately it is the state legislation, state appellate tribunal.
It's a central act.
It will go to the
it's a central
High
act,
Court,
sir. It's a central act.
Therefore, I don't think.
I don't think it's a right to put in High Court.
Ultimately, we are governed by the Constitution of India, and then.
Correct, but what about the legislative powers? What about legislative intentions? What about the speed to the consumers? What about the cost to the consumers? And what justice delayed is justice denied?
Fundamentally, I'm just asking you this.
Yeah.
If a developer appeals against an order from the appellate tribunal to the High Court, what is the speed at which that will be heard, given the fact that the High Courts already have the kind of cases that are being heard? And also, let's be honest, most developers have a battery of lawyers who are constantly fighting on their behalf in High Court over one thing or the other. What chance does the consumer have then, Ramesh Prabhu?
Ultimately, it's a question of law which will be decided in the High Court, and the facts and figures will be decided up to the appellate tribunal. So, regulatory authority and appellate tribunal will definitely decide the facts of the case.
Is the time and the cost.
The time and the all right. You know, there's one more point that we must talk about before we wrap up the show, and I want our audience to know this. Now, one of the things that we've constantly been bothered by is the fact that a lot of times developers sign contracts which say that if I delay the project on my end, I will pay you 1% or 2%. If you delay a payment on your end, you're paying 21% or 22% or 25%. We've had a lot of customers call us saying they think this is really unfair. Now, the rules very clearly state, now we know that the RERA bill said very clearly that both parties would have to pay the same interest amount. That interest amount has now been fixed as the SBI prime lending rate plus 2%. I want to ask our panel, do you believe this is fair?
Definitely it is something good. At least the rates of interest is crystallized. Otherwise, there is always a debate as to what is what. The only question arises, which is the prime lending rate? Because the State Bank will always go on fluctuating the rate of interest. Is it that always going to be a fluctuating rate of interest, or it is a date on which the contract is made or the date on which the payment is made?
I think it will have to be the interest of the day, because the contract would have been made a few years ago and the interest rate changes completely quarter to quarter. Rohit Gera?
I looked it up online, and the SBI's PLR is currently at 14.02 if I'm not mistaken, which basically means that customers have to still pay interest to developers in case of delay at the rate of 16%. And vice versa.
Rohit, I mean, the SBI PLR is at 14%. I doubt that's true. It's normally the primary
I looked
rate
it up
is
online, so I just did a
couple of
Google
points
search,
lower
so
than the mortgage rate, which is around 9.8 or 9.45% at SBI right now. So we're talking about close to 7.5% plus 2%. So we're talking about an interest rate right now of 9%, which effectively stays around the mortgage rate.
Faye, I think there's a serious problem in that. Why would a customer want to pay pre-EMIs when he can say, I've paid you your booking amount, okay? I'm not going to pay you. There's nothing which you can do and I'll pay you the interest when the time comes. Because at 9% to you, paid at the end of the period, as opposed to a monthly payment to the bank, we just won't pay.
I don't know if that's true, Rohit. If they've taken an EMI, if they've taken a home loan from the bank will disperse the amount based on a letter sent to the bank directly by a developer.
No, Faye. We've had situations where the borrower tells the bank, please don't release the next installment. We've dealt with this. This is real life.
Uday,
what are you going to do in that situation?
How likely do you think it is that average customers will take advantage of the situation in that manner?
I disagree with Mr. Gera because we have also got situations and there are proper proofs and evidences where the developer has collected directly from the bank without any approvals and without any sanctions and stages, even without any occupation certificate or stages as per the MOFA. Now,
but sir, that is why we have a Real Estate Regulatory Act coming into force now.
By
the question
coming
is
in this
under
act,
that regime.
still the interest rate is not proper. You take on the side for default of the consumer 22%, 24% as per your agreements, and when it comes to the refund, you are talking of bank rate. Let us crystallize.
Look.
So therefore, let us crystallize the rates, which will be common for both, and they should be proper.
I don't disagree. I don't disagree. The law states that. So you and I discussing this, should it be the same?
No.
It's not any matter of discussion. That's the law.
You have an option to go to the appellate regulatory authority. You can always say that more than 3 months are over, the payments are not coming, we are not interested in the interest, so we would like to cancel the documents. You can always appeal. It is not that only the consumer can go. So therefore, within 60 days, they will also decide what is to be done.
Correct.
So it is not that you are interested in paying, receiving interest, or the customer is interested in paying interest. So therefore, there is a regulatory authority. We will play the balancing act, and I think it is a fair where the rate of interest is crystallizing, which is welcome move. That's what I
want to bring in Navin Raheja. Navin Raheja, what is your response to this rate that has been announced?
I have been from the very beginning telling this is not a practical approach. I know customers will be talking against. Actually, the customer buys the property. Customers are the users. They should be compensated for the loss of opportunity, for loss of usage. The money which is paid by the customer actually gets invested into the project, and once the money has gone into land and buildings, that money is actually not yielding anything for the developer, because developer, when he made an agreement, the total contract was already frozen. He cannot earn interest on that money. And on the other hand, if the project gets delayed, the opportunity is lost by the customer for usage only. And the customer only gains it is the customer who gains for the appreciation which comes in the project over the years. So customer gains that as well. It should be the compensation should be equal to the loss of
I don't think that's fair. I don't think that's fair. A lot of times, okay, if you're talking about an investor who's done an 80-20 deal, who's put in some money and said, okay, I'm going to flip this when it's ready and I'm going to make a lot of money, that's different. That person might be gaining. But if you're talking about someone who's actually bought a home that they want to live in with their families,
correct,
they have a ticking EMI on that home, they have rent that they're paying on the home that they already live in, they have got children going to school across the street because they expected to move in at a certain point of time, they've got family members who visit who are having to, not stay in the extra room because the extra room doesn't exist, it affects their lives. let's acknowledge the fact that we are now talking about end users who are your true customers.
Absolutely.
Let's not at any point pay attention to the investors, because those investors have left the market, and I don't care anymore whether or not they're benefiting from this. But the end customer is not benefiting from delay, Mr. Raheja. I refuse to accept that.
There is an adjudication officer also.
Correct. But you know, the family wanted to move. So the cost of having equivalent apartment in the same area plus some compensation for inconvenience in waiting. I think.
But who is going to decide that amount, and how long is it going to take? We've seen how long it takes for courts to reach a consensus on what that compensation should be. It takes too long.
There is an adjudication officer where one can apply. Not only the customer gets the interest, he also gets the compensation for the opportunity cost. And that adjudication officer, none other than the retired High Court judge, and definitely they are given 60 days time to decide about this. So there is an adjudication officer which is under section 71 of the regulatory authority. So therefore, not only the customer gets an interest, even he gets the damages for the opportunity cost, and that will be decided by the adjudicating officer.
Current judgments of the consumer courts are market value, proportionate market value.
But after how long? How long does it take to achieve that judgment?
I agree, Faith. This takes about years, 5 years, 6 years. And with Mr. Prabhu saying 60 days, let me remind him, Consumer Protection Act said initially 90 days. Today also they don't have infrastructure. What RERA is going to have the infrastructure is another question.
Here, every information will be available with the regulatory authority. Everything is in their position.
Still look at
what is required is
you don't get judges, you don't have courts, you don't have infrastructure.
So
those things will come.
Things are changing. Things are obviously changing very
but
drastically
slow.
for those of us who buy homes, and definitely for those who build those homes. This is a different market. Rohit Gera, I've unfortunately run out of time on the show. I have to wrap this up, but the conversation about RERA continues. These are rules that we're going to look at very, very closely. We continue to make suggestions to various state governments whom we know are working on their rules. If you want to give us a suggestion, feel free to get in touch. Our contact details are on your screen right now. I want to thank our panel for joining us this evening, and I want to thank you for watching. Stay with Magicbricks Now. You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/MagicBricksNow. And don't forget to click the like button. You can also follow us on Twitter at MagicBricksNow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/MagicBricksNow.